Next, we're going to look at two other appellate decisions, and the reason why is it seems to me that these are egregious examples of the misuse of rap lyrics as evidence. And basically, what we're going to do is just look at the relevant passages from the decision and try to start to identify why these might be problematic uses of lyrics to convict people of serious crimes that entail serious periods of incarceration. So we're going to start with United States v. Foster and then do Cook versus State. Let me just read you the relevant short passage from the first of those. If nothing else, Hansen, now they were just referring to another case there, Hansen underscores the need to recall that the rap verse was not admitted to show that Foster was, in fact, the biggest dope dealer. It was not admitted to establish that Foster was the character portrayed in the lyrics. But in writing about this fictional character, Foster exhibited knowledge of an activity that is far from fictional. He exhibited some knowledge of narcotics trafficking, and in particular, drug code words. It was for this limited purpose that the verse was admitted, and it is for this limited purpose that its relevance is clear. And here are the lyrics. I'll actually, since these are just short, I'll read these. Key for key, pound for pound, I'm the biggest dope dealer and I serve all over town. Rock for rock, self for self. Give me a key and let me go to work, more dollars than your average businessman. And here that's the quotation, and here's the court continuing. At trial, the government offered testimony that the words key and rock were standard code words used in cocaine trafficking. Okay, so what do we have here? We have the interesting situation with the court concluding that there were fictional elements, certainly, at minimum. And it looks like actually they're prepared to concede, apparently, that maybe the whole thing is fictional in terms of the fact that this rap song doesn't describe any actual human beings or any actual events that took place. However, it does establish knowledge by the writer. Okay, now, part of what's going on here is that in a case like this one of the things that the prosecution wants to try to establish is that the defendant had the requisite knowledge of whatever is required to accomplish the crime. And in this case, the requisite knowledge, claims the court, is code words for drugs. And the thought is here that this knowledge by the writer is of a kind of a specialized sort. This is not the knowledge that everybody has, it's the sort of knowledge that drug dealers have. So it's not just that they have this knowledge, it's that they have a kind of knowledge that's, so to speak, peculiar to drug dealers. And their evidence is that the person who's being prosecuted knows the code words for drugs. Which code words? Well, there's a key is one of them, and rock. Now, let's try an experiment, okay? Go to the Urban Dictionary, which is a website on the internet, and look up key and look up rock and see what they say. If they say key can be a word used as a synonym for kilogram of cocaine or some other drug, then that looks like actually that's not specialized knowledge at all, that's common knowledge. And the same thing would be true for rock. So one big problem with United States v. Foster and potentially any other cases relying on this decision or any other cases that are relevantly similar to this decision is this notion that rap songs can be used as evidence of specialized knowledge, but in this case, key and rock are not really specialized. They're used in many different movies, for example. So it looks like the problem with this decision is that key and rock are not indicators of specialized knowledge, or even more sort of aptly specialized, relevant knowledge.